I have it. Look, I got it right there.
Oh, you're good.
Regular meeting agenda of the Miami Special Utility Authority for Tuesday, June the 18th, 2013 at 6 p.m. Filed in the office of the city clerk and posted in the main lobby in the north outside entryway of the Miami Civic Center at 5 p.m. on June the 17th, 2013. We are called to order. The trust may discuss, consider, and vote on any item listed in this agenda. Number 2, consent agenda. The following items are on the consent agenda. All items listed under the consent agenda are deemed to be non-controversial and routine in nature by the governing board. They will be approved by one motion of the Miami Special Utility Authority. The items on the consent agenda will not be discussed. Any member of the governing board desiring to discuss an item on the consent agenda may request that it be removed from the consent agenda and placed in its proper order on the regular agenda. Any member of the governing board can also move to add items from the regular agenda to the consent agenda and make one motion and vote to approve. Gentlemen, tonight you have items A, B, C, and D.
I'll make that motion to approve that.
Second.
Trustee Johnson?
Aye.
Trustee Charbit?
Aye.
Trustee Schultz?
Aye.
Trustee Weston?
Aye.
Chairman Ketcher?
Aye. All ayes. A, B, C, and D has been approved. Item 3, public input and unscheduled personal appearances. Anybody wishing to address us? None. We move to item 4, request by citizen Linda Cook to relocate utility pole located at 402 Rockdale. Is Mrs. Cook present? She contacted you to place the item on the agenda?
She did, Your Honor. Or Mr. Chairman, rather.
Well, maybe she just run a little late. We'll go on to item 5. Take no action right now on 4. 5, recommend an ordinance to the Miami City Council prohibiting new utility service to any location with an unpaid utility bill. David Anderson.
Mr. Chairman, members of the board, you have in your packet one possible proposal to address an issue which was brought to my attention by the city manager and staff. It may be beneficial first to defer to the city manager to describe the nature of the issue and why it's come before the council. Excuse me, the authority.
Thank you, David. What I have displayed on your screen for you to see right now is basically a sampling of our aging. As you can see that this is a breakdown from 1999 of our uncollectible utility balances. And as you can see, we've always had a fairly sizable but yet manageable dollar amount. But as you can see, that radically changed in 2011 and 2012, and we now have bad debt of in excess of $1 million in the utility fund. And as you can see, that that's dramatically increasing since we started farming this out to a collection agency. So our community development department was dealing with some zoning issues and started doing some digging around, and we've discovered that we have certain properties in the community that this happens quite frequently. For example, we've got one property here that has had it happen 12 times. We've had one property have uncollectible accounts 12 times. Sometimes it's 10, sometimes it's 9. We have a number of properties that have rather large, substantial outstanding balances. Most of those are commercial properties. Those aren't normal residential accounts where we have people that are not paying the last moment. So the reason why we're bringing this to you now, and we don't really have any expectation, in fact, would prefer you not take action tonight. We want to just introduce this subject to you so that you could start getting familiar with it, because we've got to do something. We're prepared tonight to talk a little bit about our business practice that we engage in now. And then David is prepared to visit with you a little bit about his legal research as to what we can and can't do. And the states that I've practiced as city manager other than Oklahoma, in some of those states, it's even the state law. You can't do anything on a utility bill other than enforce it against the meter. And we have found, I should say I found in those different states, it was the most effective tool because quite frankly, you just don't turn the power back on or the service back on until the previous account has been brought up to speed. Now that creates some special concerns for landlords who may have tenants that are leasing a piece of property and then don't pay their bill. And then when they go to lease it out again, then there's this past due balance. It's not necessarily as big a problem when we're talking about a residential property when it changes hands because it's almost always the right of offset in property transactions, and utilities are addressed during closing. So it becomes a very acute problem for landlords. Now in those states where I've been, we've had landlord policies where when we had a delinquent account, we would send the notice to the landlord in addition to the tenant. And we do have the ability to shut the power or the water off when the account becomes past due to a certain point. We do that. I would surmise that most of these are the last month that we're having problems with. Now, we've had a number of interested parties contact us about this. And I would go so far as to say that what I would go so far as to recommending tonight is that we engage in a dialogue with the landlord community. Perhaps they've got a better idea. But we've gone to quite a considerable length in trying to prevent this from happening, reviewing credit histories, requiring deposits. So we're doing as much as we can up front. In fact, we've gotten, in my opinion, a little bit overzealous in our background investigations for, what was your maiden name, who lives in the home with you, who's taking out the account. Perhaps it's somebody taking out an account for somebody else. We have that problem from time to time. And that in itself creates special problems in trying to determine what the appropriate protection the utility should have from bills that do not get paid. But it's becoming a serious concern for us. I mean, $1 million is a substantial amount of money to be having them past due, and if we continue to average 200,000 a year, it's going to add up to some very significant. And we don't want to ever come to you at some point and say we need to raise rates because we don't have everyone paying their accounts. So that's when we had David start doing some research. He looked at different options, and I think David's prepared to discuss that with you tonight. And we're happy to answer any questions you may have about our current business practices or any of the situation involving these particular properties, or you can wait and listen after David gives his presentation on his legal research.
Mr. Chairman, members of the board, when a lot of people become concerned and they want to know what a municipal utility provider can and cannot do with regard to their practices, they often go online and they look at Oklahoma Corporation Commission rules governing utilities. And while there's certainly nothing wrong with looking at those rules, the Oklahoma Constitution specifically provides that municipal utilities and utility practices are not subject to Corporation Commission rules. Certainly those Corporation Commission rules are a useful source when your goal is to come up with a reasonable regulation and not reinvent the wheel all the time. But I want you to understand and to know that Miami Public Utilities are not subject to Corporation Commission rules. That's a good thing because it means that you have some flexibility. Sometimes it's an inconvenient thing because you don't necessarily have a set of standards against which to judge your own practices. And if you set a certain rule, you may or may not know whether a court would support your decision should your policy or your practice be challenged. Now, having said that, I've looked at basically four options. One is rather obvious, and that is that I understand that the MSUA Board of Trustees and the City Council may decide at this point in time to do essentially nothing. There's certainly the possibility that you could determine that we're simply facing ordinary cost of doing business, and you may want to review it at a later date to look at trends. Option number two, of course, would be an increase in utility deposits. That's certainly something that can be, well, in fact, could only be legislated by the City Council. And if anyone's curious about how we determine or attribute the areas of responsibility between the MSUA and the City Council, I could address those questions, but I'm not going to delve into that at this particular moment. I simply want you to know that I'm well aware of the legal distinctions, and one of which is, regardless of the fact that the MSUA has a lease on city utilities and can set many policies, as a matter of Oklahoma statutory and case law, only the City Council can set rates and cannot delegate that authority. So certainly one of the options is deposits could be increased by ordinance. Option number three, and again, it's only an option, that you could make the decision that these losses or uncollectible accounts are so severe that it may become in the taxpayers' best interests that the city decide to sell utilities only to property owners. And that's certainly something you could do. A fourth option would be that you could, and there's some case law in Oklahoma that would support this approach, you could decide that you would continue to sell utilities to tenants, for example, as your primary customer, but as a matter of contract, you could require, in the case of tenants, that the property owners co-sign tenant accounts either in full or up to some determined percentage or dollar amount, so that the liability would be shared. And fifth, you have before you for consideration, and merely as an example, a proposed ordinance which would effectively, although not in specific legal terms, but which would effectively put a lien on the meter itself. And as you'll notice in the proposed ordinance, I don't use the word lien, and I don't use the word meter. I describe the service prohibition in terms of a service location or utility service location. And in the interest of due process, and that's certainly an obligation that the municipal utility has a requirement to provide, this proposed ordinance would only provide for prohibition of service to a service location with a pre-existing balance if the city had gone to the effort of filing a formal notice, in effect a lien notice, with the real estate records with the Ottawa County Clerk. That would be similar in effect to the filing of a mechanic's lien or materialman's lien. Some of you may be familiar with the fact that if a materialman provides labor or services to a piece of real estate and doesn't get paid, then regardless of who the materialman or laborer originally contracted with, they can have a statutory lien on the real estate where they performed the work or provided the materials. And so that this ordinance proposal, this fifth option, would follow a similar track and would state that you would only, in this sense, enforce a prohibition on new service if there'd been a proper notice filed in the records. For example, if a person owned a piece of real estate and wanted to sell it, but there was a notice filed in the real estate records of an unpaid utility account, that notice would pop up in the abstract, and the new buyer would have notice of what they were buying into before they closed the deal. That's something provided by law. In other words, if you file something with the real estate records at the county level, that's deemed notice to the world. Even if people aren't out reading these things, it's deemed by law notice to the world. Now, understandably, a residential tenant and likely a commercial tenant is not going typically to order or read an abstract and determine what records or what instruments may have been filed that could affect them. Nonetheless, it would be due process because state law provides that when you're dealing with estates and realty and a tenancy interest is an estate and realty, that you're charged with notice of whatever's been filed with the county clerk. And so I did attempt to introduce some due process into this fifth proposal. There may be other options available or brought to the council or to the MSUA or to the city manager, and I'm certainly open-minded about considering any and all of them as possible proposals to draft and bring to you. I'm certainly ready to answer any questions you may have for me now.
I'm like Jeff, I would like to hear from the landlords. I think that'd be a good start. I know there's got to be something done, but I'd like to hear the ideas they have.
Do we know what percentage of this is rentals versus owned property as far as?
No, we don't have any breakdown on, I mean, our intent in discussing this wasn't to zero in on rental property as much as it was past due balances on accounts. So we didn't do the analysis to determine. But, from a universe standpoint, we have about 40% tenant occupied housing, a little bit less than that. So right about 38%. So, I mean, just from the sample size, you probably would find that at a minimum it would be 40% of those, but most likely is more.
Is there statute of limitations on the time we can have to collect those?
Statute of limitations for matters sounding in contract is 5 years.
5 years?
One thing I'm also unable to tell you tonight is the efficiency of the collection activity between the former collection methodology and the collection methodology and the shift to using private collection.
Do we have any idea why the numbers have increased so dramatically in 11 and 12 compared to prior years?
Right. This the major difference that I can say is that that's about when we started using an outside agency.
I know in the fiscal year 9-10, that's when we started using.
Okay.
So assuming you're correct, in 08, the original amount of delinquency was probably about the same. We just collected a lot more. Is that the conclusion I can draw from that statement?
Yeah, I couldn't answer that tonight, trustee, because what we have is just the amount of bad debt. We don't have any. We don't have information tonight on how much we actually collected that year. We can certainly look into that.
I'd like to know as a percent of our billings what those numbers represent. I don't know that going back to 10 years really has much value. But certainly
Be 5
going
years,
back
right?
Probably, to 08 or so, 09, a 4 or 5 year history. And if it's simply that's when we change collectors, then something dramatic is different. I'd like to know what that is. And again, as a cost of doing business, I'd like to know what it is as a percent of our billings. If it's 4%, that's pretty significant. If it's 0.4%, it's not. And we just don't have that frame of reference right now.
Right.
In order to evaluate. I do think it is relevant, the percentage that are rentals, because I think that would affect our decision as to the selection if we go with one of these 5 options that David has outlined. if you find that 90% of them are rental properties, then that would kind of steer you towards one of those solutions, more so than the other.
Okay.
But I think knowing the percentage, while I'm not in favor of doing nothing, I want to at least have a sense of whether or not we're chasing pennies in the overall scheme of things. It doesn't look like it when you look at $201,000.
Well, from the reason why we go back to 1999 is that, and correct me if I'm wrong, Jill, underneath Oklahoma law, we're not allowed to write off anything. We just keep carrying these over and over in our audits, correct?
I know we have been.
Yeah, I had this conversation with Crawford, and because in other states have been, just like a business, at some point in time, you can write off a bad debt, but I don't believe we have that ability in Oklahoma. So we will continue to have these on our.
And I'm confused by that because I thought that we took action a year or so ago to write some of those off. Now, maybe we said that's what we want to do, and Crawford Associates came back and said you can't. I don't know. But I know that this council, or a previous council, tried to address this issue before.
There are outstanding checks that you've had in the past that you've taken action to write
Okay.
those off. You can do that,
Okay.
but
That's the
not
distinction.
what you're owed.
Okay.
I think is the difference.
Well, I mean, it's if we have to carry it out there in a balance sheet account somewhere, then we have to. But anything 5 or 6 years old, where we're doing nothing but tallying numbers just for the sake of whatever accounting standard we're trying to meet.
No, but even at 200,000 on a 5-year period, that becomes significant. I mean, we've got to do something inherently is wrong in either the economic situation or the collection agencies just are not being effective for us anymore. Something needs to change in that regard. Ultimately, though, again, from an efficiency standpoint, the most effective means of collecting is to prevent it from happening in the first place. And I think that was the main aim of the discussion that we wanted to have.
Under column E, how far can you go down since 5 years is the limits? What are you talking about? 2008?
Well, again, I don't have a legal background on as far as the statute of limitations are concerned. I don't know that we differentiate on the statute of limitations on our current policies as to whether or not we allow you to have service. If we find out that you owed from those past years, we may not. And I mean, I don't know that there's a legal obligation for us to provide service.
Yeah, I don't think there is. I think what David was referring to was how far back we could hold them liable
File
for the
suit.
contract, as opposed to whether or not we grant you service. I mean, if you come
Right.
to Wesco and I charged you off 20 years ago, I can say no. I don't have to grant you credit again. And I would think the city would be.
Well, is it possible that other cities that own their utilities like we do got the same problem? How did they solve it? Can we look at it that way?
Well, yeah. I mean, in most of the other communities that I've been in, and again, I apologize, my experience in Oklahoma has been limited, but we didn't have this kind of problem because if there was a lien on the meter, we just didn't turn the service back on until it was paid. It was.
What is our, what's the deposit and our cutoff policy?
I'm going to let Jill answer the question on the deposit and the cutoff policy.
The deposit, if you have an outstanding bill and if you have a deposit
Yes.
remaining, it would be applied to your bill.
Calculating the deposit is 3 months average.
A
of-
deposit for a residential is $150. If you have a bad pay history with us, it's 3 times the average at that location.
What's the average bill residentially, if you know? Well, that's kind of out of
Yeah.
left field, but 150 is,
Maybe half of it.
right.
I would say it's in the $300 range, probably pretty safely.
Yeah.
Probably now.
Fortunately, I bring the average way up.
I do too. Just a thought, that was one of the reasons for the option increasing deposits. But I certainly understand that looking at the impact of the collection method is relevant too.
So what you said is 2010, the city was doing the collection. In 2011, we gave that to a collection agency to do.
The city apparently chose to contract that out to a collection agency,
910.
910. So you had some effectiveness. We recently, didn't we, we changed companies. So I couldn't tell you, that doesn't, not reflected in here. We don't have 2013 numbers on here.
Were wage garnishment an option with the collection? Was it that harsh, or?
To get to the point of a garnishment, you have to perfect a civil judgment in a district court or a small claims court, and that's rarely been pursued because of economies. The average dollar amount of a delinquency is rarely high enough to justify going to court.
I ran into that with my own business. It just
We-
cost prohibitive.
Staff is delighted to go in and do detailed research on this and come back in a later meeting and provide you with this information. Again, our purpose today was to provide you with an introduction to the issue. And we're happy to take direction tonight and bring that back to you at your next meeting, which will be July 2nd.
Okay, any further discussion on 5? That's what we'll do, as Jeff explained it. Item 6, authorize trust manager to approve all invoices and claims not to exceed the contracted amount for the Red Robertson Event Center project. Jeff?
Thank you, Mr. Chairman. This item is a little bit different than what we normally do here because we have two trusts partnering on a project. And the MSUA is predominantly serving as the funding agency because of its credit rating. And the Miami Community Facilities Authority is managing the project. So, to avoid confusion on our part in processing claims, the Miami Community Facilities Authority is requesting that you authorize the trust manager to approve invoices and claims, provided they do not exceed the contracted amount for the Red Robertson Event Center project. They are reviewing those claims and invoices and ratifying those after they've been approved. We would also be providing those in your claims list for ratification at a later date, but because of the how fast the project is moving and staying on calendar, Oklahoma State University has requested that trust manager have that authority to be able to approve those. I'm not sure if David wants to add comments to that, but
I'm asking for his comments on
yeah.
it.
So it is a normal. Let me qualify that. Maybe normal is not the right word. It is not an unusual process in other Oklahoma communities to have administrative processes for approving claims, subject to later disclosure to the council, rather than asking the council to approve. I myself have had firsthand experience dealing with the pitfalls of having only the governing body approve financial claims, because if for the city of Miami's standpoint, if we ever lack the ability to have a quorum, then we would lack the ability to pay any bills. So, and there is no solution for Miami in that regard. Yeah, you can laugh, Council.
Didn't mean to, sorry.
That's okay. No. Just to, I'm sure there's plenty of people who are there now wondering what that was about. But when I was the city manager in Blanchard, we failed to have a meeting for 2 months because there was no quorum. So if it had not been for the fact that by ordinance I was allowed to approve claims, we would have had to have let the police go home, and there'd been no fuel for the police cars and so on and so forth. So it can get to be a problem, not when things are moving smoothly and so forth. So my point being is that it's not an unusual practice to provide that authority to staff. Now, the limitations are it has to be a budgeted amount, and in this particular situation, they're requesting that the authority be limited to the amount of the contract. That doesn't include change orders. So anything that has to be approved for a change order or any exceptions to the amount of the contract would have to be brought back. This just creates an administrative flow that makes it easier for the contractors to be able to work through the dual projects. So again, the MCFA is requesting that authority, and I'll let David.
The reason it may seem a little bit unusual, particularly in the context of Miami municipal government, is that the city council, of course, is obligated by the provisions of the Miami City Charter, and the current Miami City Charter has a provision which prohibits the payment of any claim without the city council's vote of approval. Now that's been understood to be either pre-approval or approval after the fact, but nonetheless, no payment can be made by the city council under the charter for any claim without an explicit vote of the council. That charter provision does not apply to the public trust authorities, of which the city of Miami is a beneficiary. There are certainly state laws and government accounting standards that apply to proper accounting for trust funds. And those rules do authorize you to make the decision that's been proposed both to the MCFA and tonight to the MSUA. Some of you may know that the Red Robertson Field project has a number of stakeholders, and those stakeholders are represented on the MCFA board, and the MCFA board retained Oklahoma State University as what we call owner's agent, and that's someone who coordinates a lot of the activities and makes recommendations both to the trust manager and to the MCFA board itself. In the case of the MCFA, when they voted to give this authority to the trust manager based on the advice and urging of our owner's agent, OSU. And it was explained, and Jeff, tell me if I get this wrong, but it was explained to the MCFA Board of Trustees that they were not asking that the trust manager be authorized to make these payments simply in a vacuum, but it was understood that the payments would be made pursuant to recommendation by our owner's agent. That, in other words, everything, the I's were dotted, the T's were crossed, the funds were properly allocated and accounted for, and but quite simply due and payable before the OSU owner's agent would recommend to our trust manager that he authorize the receipt of funds from the MSUA's fund held in trust by the Bank of Oklahoma that's constituted by the bond proceeds. I certainly recommend that you consider approval of the agenda item and would represent to you that it is lawful.
Thank you, David. Any questions?
This is, serving on that other trust, just to tell you, this is designed to help smooth the flow of the paperwork and the funding to the contractor for work they perform. And the owner's rep is doing an outstanding job in advising the trust. So I would make a motion to approve.
Second.
Trustee Schultz?
Aye.
Trustee Johnson?
Aye.
Trustee Weston?
Aye.
Trustee Sharbit?
Aye.
Chairman Ketcher?
Aye, all ayes. Agenda item 6 has been approved. Item 7, fiscal year 2013-2014 budget in accordance with state statute Title 60, OS Section 176G. Jeff Bishop.
Yes, Mr. Chairman, this is just a housekeeping item. We're asking the trust's endorsement of the City Council's action to approve the budget. Most of the detail was presented to you at your last meeting. The City Council authorized the budget for all of the city's functions. And in accordance with state law, we're just asking for your ratification of the City Council's action.
David, comments?
It's appropriate, sir. I'd recommend approval.
Motion to approve.
Second.
Trustee Sharbit?
Aye.
Trustee Weston?
Aye.
Trustee Johnson?
Aye.
Trustee Schultz?
Aye.
Chairman Ketcher?
Aye, all ayes. Item 7 has been approved. Item 8, other new business, if any, which has arisen since the posting of the agenda and could not have been anticipated prior to the time of posting. 25 OS, State Statutory Authority 311-9. Any new business for us? And before we go into trustee community, is Mrs. Cook here, Linda Cook? Mrs. Cook not present. Okay. All right, item 9, trustee community announcements and sign approved documents.
I have nothing,
Neil?
Mayor. I'll wait till council.
Okay. Any comments, gentlemen? Staff reports, you have written reports in your iPad. Isn't it fun to look at them? And we have staff available here if you have any questions on them. Any questions, gentlemen?
Mr. Chairman, just as a follow-up on the item that you just did not take action on, staff will reach out to Mrs. Cook again and afford her another opportunity to appear before you at your July 2nd meeting.
Okay. So we'll just pass that till the next meeting. Thank you. Last, 11, adjournment.
Motion to adjourn, Mayor.
Second?
Trustee Johnson?
Aye.
Trustee Weston?
Aye.
Trustee Sharbit?
Aye.
Trustee Schultz?
Aye.
Chairman Ketcher?
Aye. We are adjourned at 6:35. Thank you, gentlemen.
Just one?
No, but we're past 6:15. This is the last meeting that we need.
Just had one, Jill.
We'll move right into the regular city council meeting then. Call to order the regular meeting agenda of the Miami City Council for Tuesday, June the 18th, 2013 at 6:37 p.m. Filed in the office of the city clerk and posted in the main lobby in the north outside entryway of the Miami Civic Center at 5 p.m. on June the 17th, 2013. We are called to order. The council may discuss, consider, and vote on any item listed in this agenda. Item 2 is our invocation by Northwest Baptist Church Pastor Fulton Amonette. Good evening, sir. Good evening. Would you step up and give us one of those good Baptist prayers?
Let's bow for prayer. Gracious Father in heaven, we thank you for this gorgeous day. Thank you for all the blessings. And we thank you for the leadership of our city, for our mayor and city council. Give them wisdom, give them insight. Just help them to always do what is right concerning your will and what's good for the city, for the people. Lord, we thank you for each one that's assembled this evening. Lord, just bless this meeting. In Jesus' name we pray. Amen.
Amen. Thank you, Brother Philson. If you remain standing, we'll do the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Item 4, citizen input and unscheduled personal appearances. There he is.
Mayor, here I am again. It's like the bad penny keeps showing up. I just I asked for 3 minutes and feel like I can get it done in 3 minutes. But I just want the council and the city officials to be made aware of maybe a need, community need. On the last bad weather, we had somewhere near, some guesses, 300 to 400 people show up in the basement of our church to seek shelter. And some of them were even sent by city officials at the Civic Center saying go to Apostolic Assembly, which were not a FEMA-approved shelter either. But, and I heard Jeff say that 38% of our citizens rent, you know, which most of the rentals don't have shelter. And I just had an idea and thought maybe if we can consider it at some point. I believe in the middle of the Tornado Alley, I feel like we've been very fortunate as a town in Miami. We have, you know, Pitcher in one end that got totally destroyed. We have Joplin, which that storm formed over Miami and destroyed Joplin. If we could maybe consider at some point maybe a FEMA grant, I'm sure there's something out there from municipalities that we could get some kind of public shelter. We have parks in every quarter of the community, which would, I guess, be a good start, you know, and I think they could be manned with volunteers, you know, through emergency management or one of the other systems. I realize we have something even like the library that has some kind of shelter that wasn't even open, you know, for citizens to come in because it was after hours or the help got. So I'm just bringing it about that, you know, over a third of our population, and how it came to be that we had so many people come kind of took us off guard. But there is an overwhelming need in our community for this type of thing. And I think it'd be very progressive thinking to have something. And I understand maybe from the city attorneys and the city council, you're opening up yourself up to some kind of liability. Maybe not so much if you have FEMA-approved shelters, but there's a job in maintaining them, opening them, and you know, crowd control and all those kind of things. I'm asking a lot, you know, but just maybe that you consider the overwhelming need that we have in Miami for. I mean, people came from trailer homes, rentals, people that are low income that actually have homes that, I mean, and honestly, 95% of the people that came, I didn't even know. Never seen them before in my life, you know. If I have, I wouldn't know their name, you know. So the reality of it is there is a need, and just kind of want to make you aware of it and maybe see if there's something we can do. Thank you.
Mm-hmm.
Mayor?
Thank you, Pastor. Yes.
Thank you, Pastor. Mayor, members of the council, I didn't want to interrupt Pastor Shires, but on strictly a legal point, we are supposed to limit citizen comment to matters which are scheduled on the agenda. To put that another way, limit it to comment on items that you're going to be considering later tonight that are already listed on the agenda. And I would certainly encourage you, when you talk to your constituents, to discuss the possibility of including items like this on the agenda for future discussion. But again, just a reminder to avoid running afoul of the Open Meeting Act, that we restrict citizen comment to items on the posted agenda. Nonetheless, thank you, Pastor Shires.
I did call to get permission, and I wasn't told that. So
I did this.
okay.
Thank you.
I'm sorry.
No, please don't take it that way. Thank you.
Any other citizen input? Item 5, consent agenda. The following items are on the consent agenda. All items listed under the consent agenda are deemed to be non-controversial and routine in nature by the governing board. They will be approved by one motion of the Miami City Council. The items on the consent agenda will not be discussed. Any member of the governing board desiring to discuss an item on the consent agenda may request that it be removed from the consent agenda and placed in its proper order on the regular agenda. Any member of the governing board can also move to add items from the regular agenda to the consent agenda and make one motion and vote to approve. Gentlemen, tonight you have items A, B, C, D, E, F, G, H, I, J, K for your review.
Mayor, I would like to pull item J, and if there's no councilman wants to take anything else, I'd make a motion to approve the rest of them.
Second.
Councilman Johnson?
Aye.
Councilman Schultz?
Aye.
Councilman Sharbit?
Aye.
Councilman Weston?
Aye.
Mayor Ketcher?
Aye. All ayes.
No.
Go ahead
Sorry.
and do your.
I guess my question is to Jeff or David, on these rental fees, would you remind me and everybody else what the ordinance is on this?
Yes, sir. The ordinance passed by the council some months ago provides that the city manager does not have the authority to waive fees. It further provides that waiver of fees can only be made by written resolution, and that the resolution must state the public purpose or municipal function that is being forwarded by the waiver of those fees in a particular instance. Sometimes, typically when the item is placed on the consent calendar, you have a recommendation from staff for waiver. There will be occasions when there's not a recommendation from staff one way or the other, and in those cases you will typically see the item listed separately as a separate agenda item.
Counselor, I thought you may have had a question about that was there a limit on the?
I was thinking there was. Maybe I'm wrong about that. I thought there was a limit on.
Counselor, I can certainly pull that up very quickly and tell you specifically.
In the meantime, is there dates, or is it the month of June and the month of July?
One moment, sir. Jill, is this the item that there was a belief that there had been a contract let between the city and the Fair Board?
The Fair Board had made mention, I think it was to Amanda, that there was a contract that we don't know about.
But we have not been able to find a copy
Right.
of the contract. So I think the reason, there's a perception on the part of the parties involved here that previous action of the council had been that there had been an agreement struck that neither the Fair Board nor 4-H would be charged a fee. And so just as an abundance of caution, we went ahead and put on your agenda tonight. But I'll defer to the city attorney because my short-term memory isn't what it should be.
Section 27.5 of the Code of Ordinances was passed on January 24th, 2013, and it states one sentence as follows. Administrative fees imposed by the Code of Ordinances may be waived in whole or in part on a case-by-case basis only by written resolution of the City Council. I said one sentence, there's two. Fee waivers shall be granted only when said waiver serves a public purpose, period, close quote. There's no dollar amount limitation, sir.
Okay. I have nothing further, Mayor.
However, I want to make it very clear that the decision, of course, is always up to the City Council. I didn't mean to imply that the
Right.
absence of a dollar limit had any other effect.
I just don't remember this being on there last year, and that's,
Councilman, I don't know
You,
anything
Rudy?
about it or the activity.
I wouldn't remember a year ago.
Oh, there she is.
I remember her.
I'm Kathy Inyart with OSU Extension Office, representing the Fair Board. I'm not on the Fair Board, but we work with them. There are several items or events in this item. The one for the Civic Center is a 4-H activity. It's our 4-H Achievement Banquet where we honor our 4-Hers for their work throughout the year. We've had it here for many, many years. And then there are several events at the fairgrounds that are related to the fair, but fair is one of them in August, but we also have a jackpot show. This will be our third year to host it. The Fair Board does that. Our 4-H Day Camp is a week-long event. We've done that at the fairgrounds. We've also have dog training that gets ready for the fair. And let's see. Then we were supposed to have our livestock tag in this coming weekend, but due to the conflict with the tractor pull, we've moved that to another location. But the Fair Board has, and volunteers through 4-H, FFA, and all of the other youth groups have put in many hours volunteering to rebuild the fairgrounds whenever the floods came through, and so there has been that agreement to allow those things. But yes, I did come last year and get these same
Okay.
things approved, and
I
I've
just-
been several times
Okay.
to ask for a waiver. We are a nonprofit organization, and if the fee waiver is not granted, we would have to find another location.
Councilman Sharp, did you have a question about the time?
I
or did you
believe
get
she
that in?
answered them
Okay,
for me when she was talking about the dates.
okay.
I have the list if you need to look at it, but
Motion to approve.
Second.
Councilman Schultz?
Aye.
Councilman Johnson?
Aye.
Councilman Weston?
Aye.
Councilman Sharbit?
Aye.
Mayor Kitcher?
Aye. Let it be noted that item J has been passed also.
thank you
Thank you very much. Item 6, authorize city manager to sign an ordinance amending code section 3-1 to reduce local occupational taxes. Jeff?
Well, first of all, Your Honor, I can't sign any ordinances, so the item, really, we need to request the mayor's authority to sign the ordinance.
I think that was probably a typographical
A
error.
scrivener's error.
Yeah.
But to that end, we've had a number of requests to waive a certain occupational tax that the city imposes. And then rather than putting that on the agenda and asking that you waive just those particular occupational taxes, we have requested we got to looking at it and came to the conclusion that we didn't really understand why we were charging those particular fees. We went back to research the minutes. There wasn't really much in the minutes that gave us way to understand what the rationale was behind. In this particular situation, it was $1,000 occupational tax for a caterer. And I'm not a champion of occupational taxes anyway, but it led to some discussions internally with us about what we were charging across the board for some of these things that already have a pretty hefty state fee attached to it. So as to that and the full extent of the ordinances, I'll let the city attorney explain that. But I wanted to give you the reason why we put it on here was because we'd received requests from, one of them actually was the city. We were requesting a waiver of the catering license fee on the event that we're sponsoring, and the Chamber of Commerce was going to be requesting one. So David did some research and found out that legally, I'm already stepping on his territory here, legally we can only charge those on Miami residents. That if we had an out-of-town business that wanted to engage in that, we would not be able to impose those fees on them. So it seemed to me to be a bad deal to impose those on local businesses when we couldn't do it on visiting businesses. So I'll let David explain that if he desires.
Yes, sir. Mr. Mayor, members of the council, the ABLE Commission, Alcoholic Beverage License and Enforcement Agency of the state of Oklahoma, is authorized and required by state law to charge various license fees statewide. And there's as you can see in the packet, there's a litany of license fees that they charge. We then also have a state statute that says municipalities can charge local occupational taxes to those ABLE license holders up to the amount that ABLE charges as a license fee. So there can be double dipping, in other words. But the interesting thing about the ordinance from my perspective is that the state law also states that if you charge these occupational taxes to ABLE licensees, you can only charge them to ABLE licensees whose principal place of business is within the city limits. So in the context of a buy local philosophy, the existing ordinance is quite the opposite. It operates to discourage local businesses from participating. So for example, if a local restaurant whose principal place of business was in Miami, Oklahoma, wanted to engage in the catering business, they would have to pay this substantial fee not only to the ABLE Commission, but they'd have to pay this substantial occupational tax to the city of Miami. However, if an out-of-town caterer wanted to cater here, they wouldn't have to pay the same tax that the local business has to pay. And that strange limitation is not a function of our ordinance, it's a function of state law. We're only empowered to charge these occupational taxes to ABLE licensees whose principal place of business is in Miami, Oklahoma. Now, this conversation arose in the context of a caterer's occupational tax. You could decide to leave it the way it is, or you could decide to change it. But frankly, it brought up the entire discussion of whether you thought it was in the public's best interest to charge an occupational tax which could only, as a matter of state law, be assessed against licensees, doing principal place of business in Miami. And whatever direction you want to go with this, I'll certainly, field your questions and take it whichever way you want to go. But I thought that was an interesting feature in our ordinance that discouraged local business, and I wanted to bring it to your attention.
So actually, 6 has authorized the mayor to sign the ordinance
Yes,
instead
sir.
of the city manager.
It is. I can tell you that I also did check with Jill to determine the tax impact, and Jill informed me that the city, I think this last tax year, collected between $6,000 and $7,000 in these occupational taxes. So while it's not a terribly small amount of money, it's not a substantial amount of money in terms of the budget and tax receipts. And as far as we can tell, and within the city, we're unaware of any local business ever actually paying the occupational tax or applying for one. Although I know, as of the last few months, that there are local businesses that would like to do it, or say they would. Maybe the tax was designed to keep those kind of businesses out of Miami. I mean, that's always possible, but it's an old ordinance.
To that effect, we have no evidence as to what the intent was, so.
No, we don't.
We need a motion?
Second.
You want to read your motion?
Yes, I'll read.
It's-
I make a motion to authorize the mayor to sign an ordinance amending code section 3.1 to reduce local occupational taxes.
Councilman Sharbit?
Aye.
Councilman Schultz?
Aye.
Councilman Johnson?
Aye.
Councilman Weston?
Aye.
Mayor Kitcher?
Aye. Item 6 is passed. Item 7 relates back to our special utility.
Your
We'll
Honor,
just
if
take
I may,
no-
we don't have it on the agenda, but we do have authorization or would request an emergency clause for this particular ordinance, which does require a separate vote.
It doesn't have to be listed on the agenda. Simply, if you are required when you pass an ordinance to set the effective date, the ordinance gives you two options. One is to let it go into effect 30 days after passage and publication. Option 2 is to determine that there's an emergency, that it's otherwise in the public's best interest to let the ordinance go into effect either immediately or at some time less than 30 days. If you ask for an emergency clause, it does require a separate vote.
Motion for emergency clause.
For, go to effect immediately?
Yes.
Thank you, sir.
Second.
Councilman Sharbit?
Aye.
Councilman Schultz?
Aye.
Councilman Johnson?
Aye.
Councilman Weston?
Aye.
Mayor Kitcher?
Aye. All ayes, that is passed. 8, authorize city manager to sign amended lease for the former Armory building to the Boys and Girls Club. David?
You have before you a lease document that is very similar to the one that you considered at your last council meeting. I believe at your last council meeting, you did vote to authorize the city manager to execute the document. Since that time, I did receive a request from a Boys and Girls Club representative for a slight modification, and I've asked it to be placed back on the agenda. I've had a chance to discuss with a few of you the proposed modifications. Should have before you a red line document. It's identical to what you had before you at the last meeting. The differences would be the text in red. The text in black was there before. The text in blue was there before. The text in red is new. The difference is that reasonable notice for early termination of the lease is described as a period of time of not less than 6 months, providing lessee, the Boys and Girls Club, with time to relocate to a comparable facility if they need to. The term is 30 years. That was discussed previously, requested by the Boys and Girls Club because of grant requirements, and we were told there was some substantial urgency to that. I'd also point out a slight change on pages 3 and 4 in the red text. There was a term, the word impractical, that's been lined out at the request of Boys and Girls Club. I've considered that, reread that paragraph several times, and the deletion of the term impractical, in my legal opinion, would not change the city's position under that paragraph. And by the way, that paragraph pertains to the application of future floods, flood insurance, and future floodplain administrative restrictions on reconstruction. So those are things we have to deal with, and I think the Boys and Girls Club understands that. Having said that, I'm prepared to answer any questions you may have, and subject to those questions, my recommendation is that you consider approval. The Boys and Girls Club will meet tomorrow. If you authorize the city manager's signature on the document, it'll be presented to the Boys and Girls Club tomorrow for their board's approval.
Jeff, you have any comments on this?
No, Your Honor, the staff has looked this over. We've been involved in reviewing the language, and we don't have a problem with it at this point.
Okay, thank you.
You just need a motion on the amended contract, or
I would simply seek a motion on the lease agreement as presented tonight.
I'll make that motion.
Second.
Councilman Johnson?
Aye.
Councilman Weston?
Aye.
Councilman Schultz?
Aye.
Councilman Sharbit?
Aye.
Mayor Ketchert?
Aye. All ayes on item 8. It's passed. 9, authorize mayor to sign ordinance to amend ordinance 1545 to incorporate the ability of using state bids without the second competitive bidding process. Randy Hines and David Anderson. Hi, Randy.
Hello. I don't get up here very much anymore. A little background, the current purchasing ordinance authorizes the use of state bids, but only after the city does its own bidding process and compares their outcome to the outcome of the state bids. The redundancy is obvious and in effect ties the city's hands into a second competitive bidding process after the state had already completed one. Legal has amended the wording to give an either-or direction. The city may still do a competitive bidding and compare it to state bid when there is a belief that the local vendor may have a shot at being awarded the bid. But in a lot of cases, they don't sell the item or for whatever reason, and it's just be rebidding, doing exactly what the state already did. So we're asking to change the verbiage that's in the ordinance so that we can do an either-or.
Your Honor, if I could add a little bit to this.
Sure.
I mean, give you some specific examples where it doesn't work for us to do both. In the past, we have been bidding out crack sealing on the streets. And ironically, our bids have been coming in higher than the state contract. But what makes it really interesting is that the low bidder, even at that point, is the same vendor that's on the state contract. So in those situations, we're actually paying more from the same vendor than if we had gone directly to the state contract. Some other areas, we have in the past bid police cars and bought many of them from Vance Ford here in town. Ironically, Vance conglomerate has almost always one of the state contracts on police cars, and they are sometimes cheaper on the state contract than what we've seen. So in instances where we know that we've had experience that the state bid is going to be cheaper, there really is not a lot of sense in going through that second process of bidding it ourselves rather than just buying it off state contract. Now, we would not do this in situations where we know we're going to have a local vendor that is going to be competitive with the state contract, or if there's an inherent public purpose in providing that business to a local vendor. That being said, though, I mean, to a certain extent, we want to try to find the best value for the taxpayer. And we think that giving this option of us to being able to, when we know that we're not going to do better than the state contract, that we just go to the state contract. In the event that it becomes a concern for the council that staff is not giving enough attention to a local process, council always has the ability to change the process again and request staff do something differently.
I'd like to do a little bit of legal background for you. This topic is something that I had exchanged some email communication with and some other communication with Mick Dodson with the state auditor and inspector's office. And I'd like to say that interestingly, when I gave him my analysis in writing, he responded that he agreed with it, which take that for what it's worth. I'd like to point out that he didn't, of course, review this particular ordinance proposal. It was just the analysis. The current ordinance that we have specifically requires that every contract for the purchase of supplies, materials, or equipment exceeding, in the current case, the $50,000 threshold provided by state law shall be purchased from the lowest and best bidder after due notice inviting proposals by the city or any other political subdivision in the state with similar or more stringent bidding requirements. As Mr. Hines said, under the existing ordinance, if the purchase of supplies, materials, or equipment is going to be over that $50,000 threshold, then the state, then the city has to utilize the full bid process. And certainly could continue to do that, either if you don't approve the ordinance or you want to see it applied in a different way. You'll also notice that in the proposed ordinance amendment, I did delete the provisions that would have allowed for piggybacking on other municipalities' contracts for bid. I will tell you, and I put in the materials, that I'm reluctant to retain the piggybacking provision because I think it would make the city essentially provide a legal warranty that the other political subdivision properly follows state law and their local charters and ordinances, and it's difficult for me to responsibly advise you to do so. And so as part of this ordinance, I've recommended that you delete the piggybacking provision. However, as to the purchase, for reasons related to state law and the municipal charter, it is possible to for the city council to authorize contracts for the purchases of equipment exceeding that $50,000 threshold. And so this ordinance would provide that in the case of the purchase of equipment, not supplies or materials, but only equipment, that the city could purchase directly from the state central purchasing office awarded solicitation lists, or provide for lowest and best bidder through open bids and competition at the local level. If in that particular case, under this proposed ordinance, the lowest and best bidder was still higher than the state awarded solicitation list through central purchasing, then the ordinance would declare that the state list would be considered a bid for purposes of purchases of equipment. Hopefully that makes some sense. I just wanted to clarify that really the only two changes in the proposed ordinance would be the deletion of the piggybacking provision, and would be the provision that purchases of equipment over $50,000 could be made either directly from the state list or through local competitive bidding. You would still have the option in any particular case to discuss which direction you wanted to take that particular purchase.
Questions, gentlemen? Let's have a motion.
Make motion.
Second.
To approve,
I think
sir?
they want us to read what's up there. Can you see it?
Don't have my glasses on.
There you go.
I'll make a motion to move to authorize the mayor to sign the ordinance to amend ordinance 1545.
Right.
Councilman Weston,
Aye.
Councilman Sharbit,
Second.
Councilman Johnson,
Aye.
Councilman Schultz,
Aye.
Mayor Ketcher.
Aye, all ayes. Number 10 has passed. Thank you.
I don't know if there will be consideration of an emergency clause or whether that's requested by staff.
Staff doesn't view this to be an emergency.
Thank you.
I'm sorry, that was number 9 that was passed. Number 10's other new business, if any, which has arisen since the posting of the agenda could not have been anticipated prior to the time of posting. 25 OS Statutory Authority 311.9. Any comments on staff reports?
No, sir.
I'm sorry. I'm one ahead all the time. Number 10, no new business. Number 11 is staff reports. You have written information on your iPad on different things prepared by the staff. Do you have any questions on that information?
No, sir.
And do you want a 5-minute break, come back and go into executive session?
Please.
Okay, we're going to
Mayor, can we
5-minute
do
break.
the community?
Yes. Before we break, Neil has an announcement here
Thank you, sir.
on the community, number 12.
Thank you, sir. As I mentioned to you earlier, Mayor, I was at the Animal Welfare Society today and talking to Irene. They need some volunteers at the animal shelter. She told me they have over 100 animals now, the most they ever had. And I want to go through some names here, and I want to thank them. I know everybody up here appreciates the job they do. Irene Cahealy, Rena Helm, Sam Bates, Diane Headley, Annette Watson, Nancy Goforth, and if I missed anybody, I apologize. But they do outstanding work down there, and if you just have an hour, 2 hours a week, it would be appreciated. If you're looking for a good pet to adopt, they have a bunch, and any kind of help that they can get, they would appreciate. And that's all I have, Mayor.
Okay, thank you, Neil. Taking care of our animals is a big project here. If it wasn't for that facility down there on East Central, we'd have a terrible problem. We need to do something about our pets because we don't know how long this lady will be able to continue. She does have, from time to time, a little help, but she basically is down there 7 days, morning and night, watering and feeding and cleaning up those pens for those animals. She gets very little assistance from our community, and that needs to change. If you're an animal lover, you can go down there, and they have purebred dogs and some cats from time to time. And right now, I think they have a lot of kittens.
She
that
said
they're
they have a
trying.
bunch of kittens.
Yeah. So it's important for you all to be aware of that. And also, if the dogs don't get a home, we have to euthanize them. We have to kill them, dogs and the cats. And that doesn't speak well of my hometown, Miami. I'm an animal lover. I have 2 dogs, did have a cat. She died. But we need to pitch in and help this lady because it is important to Miami. Okay, I guess we'll go into our
Break. That's fine. You got more? It only take about 10, 15 minutes. It ain't no big deal. 10? Okay. Yeah.
Thank you, gentlemen. We're back in session now.
No.
Item 13, executive session pursuant to 25 OS 307B4 for confidential communications with the city attorney concerning a pending investigation, claim, or action to wit, Darrell Buckmaster versus City of Miami, Ottawa County District Court Case Number CJ-2013-77. The city attorney advises the city council that public disclosure of confidential attorney-client communications in this matter would seriously impair the ability of the city council to conduct the litigation in the public interest. The Oklahoma Open Meeting Acts prohibit public bodies from going into executive session unless authorized by a majority vote of a quorum of the members present, and the vote is a recorded one. See 25 OS Section 307E. No vote may be cast in executive session. See 25 OS Section 305. Gentlemen, do I have a motion to go into executive session?
I would ask that any motion include the determination, that'll be the action item after executive session, include the determination, if you agree with me, that public disclosure of this legal advice that I'm going to give you in this pending lawsuit would seriously impair the ability of this body to conduct the litigation in the public interest. And if you make a motion, I ask that you adopt that language.
I make a motion, we go into executive session based on the fact that open discussion of the matter would seriously impair the ability of the city council to conduct the litigation in the public interest.
I'll second Councilman Schultz's motion.
Councilman Schultz?
Aye.
Councilman Johnson?
Aye.
Councilman Weston?
Aye.
Councilman Sharbit?
Aye.
Mayor Ketchert?
Aye. Gentlemen, we're in executive session at 7:21. Thank you, gentlemen. We're out of executive session, back in regular session at 7:44.
I'd make a motion to ratify the city attorney's filing of an answer in the Buckmaster suit and direct the city attorney to notify our insurance company of the suit, of the claim, and proceed to defend.
I'll second, Mayor.
Councilman Schultz?
Aye.
Councilman Johnson?
Aye.
Councilman Weston?
Aye.
Councilman Sharbit?
Aye.
Mayor Ketchert?
Aye. Item 14 is passed by an all ayes. 15, adjournment.
Motion to adjourn.
Second.
Councilman Schultz?
Aye.
Councilman Weston?
Aye.
Councilman Sharbit?
Aye.
Councilman Johnson?
Aye.
Mayor Ketcher?
Aye. All ayes, we're adjourned at 7:45.